All right, thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakrin, here joined by attorney Holly Waltman, our special guest analyst joining us today here on ANF Plus. Thank you so much for being with us, Holly. Holly is a local Atlanta-based attorney and here to talk about several top legal stories that we're following right now. The first one that I want to discuss with you, Holly, is regarding Fulton County DA Fani WIllis. So this is a major story for us. She has spoken out publicly for the first time following allegations of impropriety or misconduct. So she essentially has defended her office after these allegations of an improper relationship with one of her team members. This surrounds her alleged romantic relations with a special counsel on the Trump election interference case, the special counsel Nathan Wade. And WIllis made her first public comments since the accusations, just speaking yesterday at Atlanta's oldest black church, Big Bethel EME. She never confirmed nor denied the allegations, nor mentioned names of her special prosecutors. But let's go ahead and listen to her remarks.
I hired one white woman, a good personal friend and great lawyer, a superstar, I tell you. I hired one white man, brilliant, my friend, and a great lawyer. And I hired one black man, another superstar, a great friend, and a great lawyer. Oh Lord, they're gonna be mad when I call them out on this nonsense.
All right, so again, the special prosecutor Nathan Wade is a focal point of these accusations. He was in court Friday for the latest round of hearings over former President Trump's Georgia indictment. DA WIllis has not filed a response to these allegations just yet. All right, Holly, what are your initial thoughts on her speaking out, this latest development?
Well, look, Joy, I think it's important to note where she was, right? She is in a church setting, speaking to a congregation of individuals. She is not in a formal courtroom setting, and you can even hear in her dialect, you know, the way and the manner in which she addressed this crowd is certainly going to be different than when she actually responds to these allegations in a more formal setting, such as a courtroom.
Yeah, absolutely. All right, so underlying all this, of course, is the accusations, right, of this impropriety. Let's kind of, it's a lot to unpack here. So first of all, you know, people do have a right to a personal life, right? But the question is, should she have appointed Nathan Wade to be a special prosecutor in this case to handle the Trump investigation, which ultimately resulted in this massive indictment? That's the first question. Was that proper in your view?
So there's certainly avenues in which someone like Fani WIllis or a district attorney, an elected official, can bring in outside help, right? When there's conflict of interest, this is something that we commonly see in the legal community. There are very specific ways in which someone would be qualified to do that. Certain checks and balances, if you will, that have to be achieved in order to properly use public funds, taxpayer money, in order to prosecute or investigate these sort of matters that happened inside of Fulton County. It's yet to be determined, and of course, I believe Fani and her office have explained that they do plan to formally answer to the written motion that Mr. Roman's counsel has filed. And I do believe that we also see a possibility later down the road, after this hearing is scheduled, on if other co-defendants join this motion. And I think that a lot of people are waiting to see what is the actual evidence behind these allegations.
All right. So if these allegations are true, do you think that the charges should be thrown out? Because, I mean, you know, obviously we reported last week that there was a motion to dismiss filed by the attorneys for Michael Roman, who you know the attorney, and thank you for, you know, your help behind the scenes actually on that story. But, you know, the motion was for the charges to be dismissed, for both WIllis and Wade to be disqualified from the prosecution of this case. Do you think that even if there was this sort of impropriety that is alleged, that it is actually a fatal error, a fatal flaw to the case, that the charges should be thrown out, or that these individuals should be disqualified?
So I do know the attorneys on both sides of this this case and on this motion rather, and Ms. Merchant very thoughtfully wrote and scripted this very voluminous motion, right? But it was written in such detail, right, that it was easy to understand. It was not it's not a legal based argument. It is very written in plain English. And if that motion is granted in full, then yes, it would require the court. It's one of the only times that the court can actually step in on certain charges, and it would require the court to dismiss the indictment in its entirety for all of the co-defendants, not just Mr. Roman.
Okay. All right. Interesting take. But what do you think is left? What do you think needs to happen for that motion to be successful, for the charges to actually be dismissed?
So just like the allegations against Trump and his colleagues, they have not been proven, right? So those individuals have the presumption of innocence in their favor. And Ms. WIllis and her office have not responded to the allegations in the motion filed on behalf of Mr. Roman. So, of course, just to be fair and in the interest of justice and fairness to everybody, she's going to respond. And then the judge, of course, will take under advisement not only her written response, but also the oral arguments that will be scheduled and be heard by both sides prior to making his ruling.
So, there's so many elements to this story. We understand that Ms. WIllis has also now been subpoenaed to testify in the divorce proceedings of Nathan Wade. First of all, do you think that she will? And second of all, if she does, how could that impact this larger case?
Well, Ms. WIllis is an officer of the court. She's a prosecutor. She understands the power that the court has with its subpoena power. And if there is a subpoena that has been properly served on her, she will comply with it, right? Now, what it is she can say or can't say or even testify to is yet to be determined. But remember, that is a civil matter and it's held in a different county. So it is not held within Fulton County or her office. Her office has the sole jurisdiction of prosecuting felonies in criminal matters, so completely different proceeding. Will she testify? I think she will comply with the subpoena as officers of the court were sworn to do.
That said, can't she motion to quash the subpoena?
Certainly she has that option, and I'm sure she's speaking with attorneys to explore whether or not that's something that is a viable legal avenue for her to do.
All right. Any other thoughts on this situation, this case?
Yeah, Joy, what we were talking about earlier when I said, when you asked me the question, if this motion is granted, does it require the court to dismiss all of the charges in the entire indictment? And that is true, but also there is a chance that it is completely denied in full, or there's also kind of an in-between ground where it's granted to some parts and denied on some parts. So that is also still available to the court, and it'll be largely based on, like I said, the written response from Fani WIllis, as well as oral arguments from both sides.
All right. And what do we expect moving forward now?
Well, we have to wait for her response. We have to wait for the court to schedule that hearing, and then, of course, make his ruling. Judges can do that from the bench the day of the hearing, or they also can take some time to go back and research the legalese and the law that applies to each side and give out a written ruling. So we're yet to see which way this judge will go, but I'm sure he will take every angle under consideration and wants to get this right.
So, big picture, if you're a defense attorney, is it a good tactic to delay, to kind of make the prosecution, challenging? So if you are, Ashley Merchant, who represents Michael Roman, one of the defendants in the election subversion case, is that one of kind of like the motivating factors to try to, make it difficult to prosecute her client?
So that's certainly a tactic that defense attorneys can use and often use, because oftentimes the delay is in our favor, right? Memories fade, eyewitnesses change their mind or forget, evidence gets old, it's not as ripe. So that is a tactic that defense attorneys use. On the other side of that coin, there is the right to demand a speedy trial. And sometimes defense attorneys want to put the pedal to the metal and speed up these proceedings for whatever reason. There might be a legal reason or a strategy or a technique reason to do that. In this case, I think the challenge that comes with prosecuting people on a co-defendant or a RICO statute under one indictment is that if one of these co-defendants files a demand for speedy trial, it could actually pull the other co-defendants into trial with that individual. So what I think is going to be most interesting is, are all of the co-defendants on the same page on the timing of the trial, and whether or not delay or speeding the trial up is in collectively all the co-defendants' best interest.
Got it. Okay, that's a great point. So, in fact, will this create another delay? The fact that there's this motion and this, we're doing news stories about this alleged impropriety, whether it actually happened or not. I mean, we're reporting it because it is an allegation. There was a motion filed. It is something that the court is considering right now. So, how does this impact the timeline of the underlying prosecution of the election subversion case?
Well, anytime a defense counsel or any party files a motion that requires or requests the court to put it down for a hearing, of course that's going to delay the proceedings. It's also yet to be seen if other co-defendants plan to join in on that motion, and whether or not they will present evidence or they will present arguments to the court. If they join in on Ashley Merchant's and Michael Roman's motion, they also might file an additional motion or a supplementary motion if they have additional evidence or additional things that they want the court to consider. So of course this will delay, and I expect the delay to grow bigger if other co-defendants or other counsels join in on the argument.
But just how much delays, that's yet to be seen.
Yes, correct. Of course, there was a scheduling order filed in this case early on, putting all of the parties on notice that this is the intent of the court and this is the timeline to go to trial. If you recall, Joy, we were here just last year in the winter. I think it was November or December, and I think Ms. WIllis announced that she plans to try these individuals in Q1 or Q2 of 2024. If that timeline is still on the table, is yet to be determined. It is not, in fact, something that I've heard her say recently as of these filings and other motions that have been filed.
Got it. Okay, let me ask you about another top legal story that we are following right now. It's now the 1-year anniversary since the deadly UGA crash. This crash killing football player Devin Willock and staffer Chandler LaCroix. Both of them killed in this car crash. Police ruled that alcohol and speed were factors in this early morning accident following Georgia's national championship parade. And in the months after, head coach Kirby Smart said that LaCroix, who is behind the wheel, was in violation of a school policy driving a company vehicle after hours. So now there's some new allegations, new court filings accusing university football officials of knowing that staff members frequently used school cars after drinking. The university has not responded to the allegations. Let me go ahead and play this story prepared by my colleague Patrick Quinn for some context.
It's been nearly 1 year since this tragic crash left one UGA football player, Devin Willock, and one staff member, Chandler LaCroix, dead. Police ruled alcohol and speed were factors in this early morning crash following Georgia's national championship parade. In the months after, head coach Kirby Smart said LaCroix, who was behind the wheel, was in violation of a school policy in driving a company vehicle after hours.
That policy was broken, and it's to be understood that you cannot take a vehicle when you're not doing your duties, and they were not participating in their duties at that time.
But in new court filings, the attorneys for Tory Bowles, another staff member in the back seat of the car that crashed, alleged that university officials not only knew staff members had company vehicles after hours, but they were instructed to keep them overnight. Here, a recruiting staff member in December 2019 texting Bowles to, quote, "Yes, take it home." The 75-page complaint continues, saying, quote, text messages show that on occasion supervisors and coaches, in effect, encouraged recruiting staff to drink alcohol with football prospects' families, well aware that staffers would leave the events after consuming alcohol. In this text exchange, the football program director of player personnel told staffers, quote, "Hey guys, if you are driving, you can have fun at Coach Smart's, but if you are driving a recruit, make sure you don't get drunk." Bowles, whose attorney said was seriously injured in the crash, is seeking upwards of $200,000 to offset medical bills and lost wages. Patrick Quinn, Atlanta News First.
All right. So, Holly, several legal issues with this case, of course. But, the newest allegations, of course, is what we just heard from Patrick. These allegations that, essentially the university staffers knew that some of the staffers would use company vehicles and drive drunk after the crash. What is the liability there? drive drunk. I'm sorry, not after the crash, preceding the crash, but they would drive drunk essentially.
Yeah, Joy, I remember this story. It was such a sad, tragic story last year when this news broke. To find out later through the discovery process, and that's the tools that attorneys use in order to gather evidence about the other side of the lawsuit, that just kind of adds insult to injury. When you have speed, when you have alcohol, and then the third deadly combination are young, inexperienced drivers, it's just bad things happen, and this is a tragedy all around. I think that as more and more evidence comes out and we see that who knew what and how they knew, I think we also are creating an internal investigation that UGA is having to make within their program to find out exactly the extent of this, how widespread it is, and how often it's happening.
Yeah, absolutely. Any final thoughts on this topic?
It's just such a sad story. I hate to see it, and again, don't drink, don't drive.
Yeah.
Pay attention. Don't be texting. I mean, it's so important. Ubers, ride shares are out there.
100%.
They sadly could have all been not a reality.
Absolutely, absolutely. Thank you so much, Holly, for your take on that. Before we let you go, I also want to ask you about another top legal story that, of course, very big for us here on Atlanta News First. We have been streaming gavel to gavel the YSL RICO trial, and actually court is dark this week, but we when we last saw court in session on Thursday, it was actually dark on Friday. It's dark all this week. It will resume on Monday. When we last saw testimony, we were hearing from a former defendant, Trontavious Stevens, who turned state witness. He pleaded guilty, turned state witness. He said that he essentially has testified that he co-founded the YSL gang with Jeffrey Williams, aka Young Thug, that it is a gang, that he helped co-found it. He also testified that all 6 defendants who are on trial were gang members as well. How do you think that the prosecution is doing overall? How do you think the defense is doing?
Yeah, so Joy, when you have individuals that come to testify for either side, and they used to be defendants, right, and they've made some sort of proffer or some sort of deal for leniency in their sentence, it always brings, to me at least, the question that what kind of credibility can this jury gather from someone who is coming in essentially as a puppet for the state to testify against somebody else in order to benefit himself? They are subject to having their deals, if you will, or their plea agreements that were reached withdrawn, right? And he's looking at tougher sentencing and jail time, prison time perhaps, if he doesn't come in and testify in the way that is in line with the state. So he is not like an unbiased witness or party. He is a very interested party, and he has a lot of his own skin in this game, if you will, to come in and testify the way that the state is asking him to. I think that the jury will have to wait and see what they think about it, and if it's credible evidence that they give weight to in this case.
Yeah, absolutely. Holly, any final thoughts before we let you go here?
I like this case. I like the attorneys on the defense side. They're very brilliant, and I think that they are doing a nice job of trying to give everybody a little bit of reprieve, because as we know, this is a marathon trial. This is the longest criminal jury trial in Georgia history so far. And a lot of additional pressure has been added to this because the same office is now prosecuting the other RICO case that we're covering with Donald Trump and his associates.
Yeah, absolutely. Okay, Holly, finally, our viewers may be watching you right now, and maybe they need legal counsel. What kinds of cases do you take, and how do people get in touch with you?
Yeah, I have a criminal defense law firm. We have 2 locations. One's in Cobb County, one's in Forsyth. I do complex criminal defense all over the state of Georgia on state and superior court levels, as well as federal work. You can reach me at hollywaltman.com or thewaltmanfirm.com. We're on Instagram and Facebook at the Waltman Firm.
All right. Well, thank you so much, Holly Waltman, joining us live with analysis here on Atlanta News First Plus. And just a reminder, as we were talking about the YSL case, again, it does resume on Monday, and you can watch our gavel-to-gavel coverage on Atlanta News First Plus on our special events stream. And our regular over-the-air broadcasting begins at 3 p.m., and you can, of course, watch all of your top stories here on Atlanta News First and Atlanta News First Plus. Thanks, and have a great day.
he was detained without incident.